Hi, everybody. Welcome. I missed you guys last week. Yes, it's still very smoky here, so I still have a scratchy throat. Um, we still have a lot of smoke rolling in from the forest fires on the West Coast. So we're not in an area where we're at all at risk. All of our friends and family are safe, but we do have many large wildfires in the Pacific Northwest, all the way up the coast from California. There are several within the Central Oregon area, but none of them that are threatening any major population areas. So we're all safe, but the smoke just settles against the Cascade Mountains, and that's where it stays until we get some substantial rain. And so we'll wait for that. Hi, we have so much to talk about. First of all, thanks for your patience with my not being here last week. We got my mom moved from Boise over to Redmond, Oregon, and settled her into her new assisted living facility. And she seems to be settling right in and seems to be very happy with it. So it was kind of a busy week. We went over on Monday, came back on Tuesday with all her stuff, and then got her all settled in. So, but there's also been a fair amount happening in the true crime world that we really need to talk about. So let's dive in. I do have a couple things that I wanted to mention before we dive in. One, those of you who are in the Book Launch League should have gotten not one, but two versions of a PDF. When my publisher sent me the initial version, she told me that that was the final edited, cleaned up version, but somehow the file had been overwritten by a prior version. So I then sent out a second PDF, which was the for real, for sure final version that had the chapters on Chad's trial and verdict, as well as the final version of the epilogue. So thank you for your patience. I hope you caught those. I really appreciate the number of people who have been willing to read and are ready to post reviews once the book hits. I got word from the publisher that they are in the process right now of recording the audiobook. So for all of you who are waiting and hoping for the audiobook, it is in process. And the digital version will be available for Kindle and tablet use. So there will be a digital version as well. So there was a hearing in Chad Daybell's case with Judge Boyce today, actually. It was a little bit of a maybe slightly unimportant case, but it's worth remarking on. The attorneys who have taken over the let me see if I can get this right. There are two motions pending. Well, there's a motion for a retrial. There's also an appeal pending. So the attorneys who are now representing Chad, who are public defenders and who are death penalty qualified public defenders, asked Judge Boyce for additional time for both of those motions. And the reason is that they have received, the trial transcript alone is 6,000 pages. They also have received many terabytes, as you know, of evidence that was presented at trial exhibits. They also expressed a desire to review Lori Vallow's trial, which makes sense because of the the same evidence being brought in both trials. So they're asking for extra time for both of those motions. And Judge, as far as I could tell from the hearing, Judge Boyce has granted that. He did push back a little bit on them because they filed a 250-page motion that he felt like they at least had some information already about the case if they were using it as the basis for a motion. But there's no question that file is enormous. They also commented that part of the problem was at least 60% of the court files were sealed, which we know, and they didn't have access to until about 2 weeks ago. So that is an interesting and ongoing issue. As you all know, it's not an issue that I'm going to let lie, so we'll see how that all works out. Lori Vallow's trial is set for January 2025, February 2025, I believe. Hold on, let me look at my notes. February 2025. Do I think it'll go then? Possibly. So there are a couple of other things coming up that are fairly interesting that I think we all are going to want to focus on later on in the month. Corey Richens is finally going to get a preliminary hearing on August 26th through 28th. She has been in custody for a very long time. Her attorney, Scar Lazaro, who is a very well-known and well-respected defense attorney, withdrew, citing a conflict, although I think there's some discussion about the fact that Corey's also out of money. She doesn't really have money to hire a different private attorney. Corey Richens was retained. She was a private attorney. So she now has a public defender, and that created even more delay than there had already been. So for those of you who don't remember or are not familiar, Corey Richens is the Utah mom who is accused of lacing her husband's Moscow Mule with fentanyl and murdering him. It appears because he was getting wise to her money schemes. She was very, very far in debt and was buying and selling and flipping houses. So that is probably the next thing that's coming up. Richard Allen, and we're going to talk a little bit about Delphi tonight, but Richard Allen is set for trial in early October, well, mid-October, October 15th. The James Craig trial is coming up, and my understanding is it starts tomorrow. So I will be looking into that because there were folks who asked me to follow that one. Brian Kohberger, the Kohberger case is still hanging out there. There were hearings on the issue of the change of venue motion, which I believe Judge took under advisement. So we're still waiting for an answer on a change of venue, but I would be very surprised if it's not granted. So let's dive into some of the stuff that's happened in the last couple of weeks. First of all, there is a hearing on Friday, the 9th of August, on the Reed case. Karen Reed was accused of having run down her boyfriend, who was a Boston police officer, and left him to die in the cold. There was a 10-week trial, and at the end of the 10-week trial, the jury reported that they were unable to reach a verdict. Later then, the jury contacted both the defense and the prosecution and said, we actually reached a verdict on 2 of the 3 counts. The count 1 being the most serious count, the count having to do for second-degree murder. And the count 3 was intentionally backing over him while intoxicated, basically. So the jury reached out first to the defense and then to the prosecution and said, wait a minute, we reached a verdict on 2 of the 3 counts. There are some real problems with this. Those of you who follow the Karen Read trial know that this trial has been a mess for a very long time. And there are a number of problems with this. But here's the issue. When the judge, and if you go back and watch the judge's decision on the hung jury, the jury comes back in, the judge reads the jury's letter and says, I'm not going to require you to deliberate any further. I'm declaring a mistrial. Now, she did not, before she made that decision, ask for any sort of input from either attorney, which is unusual. Usually a judge would say, I'm considering a mistrial. Do you want to be heard? The other thing that didn't happen was neither side asked the judge to poll the jury. Now, y'all who've been watching trials for a while have been watching long enough to know that when a jury comes back with a verdict, the judge always asks, do you want me to poll the jury? It's very unusual for a defense attorney to say, no, I don't want you to poll the juror. Well, the judge didn't ask, and the attorneys also didn't raise the issue of asking to have the jury polled. Had they done that, it's likely that they would have ferreted out the fact that the jury had actually acquitted on 2 of the 3 charges, but they didn't do that. Now what's happening is the defense is saying double jeopardy attaches to those 2 counts and that they should not be retried. So they're asking the court to dismiss those 2 charges. The prosecution is saying, no, double jeopardy did not attach because the jury was hung and we have the right to retry the case. So the arguments are going to be heard on Friday, having to do with both sides' arguments on the record as to what to do about this. Now, the judge could take statements from the jurors, either as affidavits or in person, and confirm with the jurors what their understanding is. But here's the dilemma. The dilemma is how much can the judge invade the purview of jury deliberations? Jury deliberations are absolutely sacrosanct. They are sacred. You cannot invade the jury deliberations, period. So you cannot ever ask a jury what happened in the jury room, who was for, who was against, who was. But I do think that the judge can ask the jurors, what was your decision on count 1? The judge can ask each one of the jurors for their decision. It's essentially polling the jury late. Now, if I were the state, I'd be arguing like crazy. There's an awful lot of time that's gone by. These jurors have had an opportunity to look at TV, to watch the trial, to listen to commentators, and there is absolutely no way for us to know at this point in the proceeding that the jurors found her not guilty at the time of trial. We have no way to be sure that they didn't change their decisions and are only now just saying that after they had the ability to watch all of the TV coverage and all of the commentators. So I don't think that the judge is going to make a decision from the bench. I do think that she's going to take it all under advisement and probably issue a later decision. And if I had to guess, I would say I don't think that she is going to order the charges dismissed. Now, the prosecution still has the ability, because prosecutors have discretion, the prosecution still has the ability to decide not to recharge those two charges. Would that be the ethical thing to do? I think so. But the question is whether or not the district attorney is going to see it that way. So it is absolutely a mess. This case has been a mess since it started. And the frustration, I think, for me, and I think for most people, is that as this case has gone forward, and there's been so much question of the ethics of the law, of the police, and the ethics of the prosecutor, and all of those issues, that it is very possible that we are never really going to see justice. John O'Keefe's John O'Keefe's family are never going to get the kind of closure that they deserve and the justice that John O'Keefe deserves. It's very unfortunate. So that case continues to perk along. The next case I want to talk about is Hannah Gutierrez. Now, Hannah Gutierrez was the armorer on the Rust set, and was the person responsible for the guns and the weapons during the filming of the movie Rust. You might recall that Alec Baldwin was on trial for similar charges, and his case was dismissed with prejudice because of misconduct on the part of the prosecutor, who was an appointed special prosecutor. She was not a member of the district attorney's staff. So since that time, promptly after Baldwin's case was dismissed, then Hannah Gutierrez's lawyers filed a motion asking to either dismiss the case or to give Hannah Gutierrez a new trial. And their argument makes a little bit of sense. They have pointed out that they have discovered, because of Alec Baldwin's trial, they realized that there's over 900 pages of discovery, including at least one additional report about the gun that were withheld from them during Hannah Gutierrez's trial. Probably the most telling thing is that Alec Baldwin has always claimed that the gun went off without him pulling the trigger. And there is an additional third report that was never disclosed to Hannah Gutierrez's counsel that indicates that there were tool marks on the trigger of the gun that were not caused by the FBI damaging the gun, were not caused by any other investigation, and potentially could have backed up Alec Baldwin's contention that the gun malfunctioned. So I think that at a minimum, Hannah Gutierrez is going to get a new trial. But this judge, the same judge that heard the Baldwin trial, heard the Gutierrez trial. And I think that if there is a hearing at which she is presented with the fact that there were 900 pages of discovery that remained undisclosed, I think there's a good chance she dismisses Hannah Gutierrez's case too. I find the misconduct on the part of this prosecutor absolutely appalling. It's just inexcusable. It's inexcusable arrogance and inexcusable just sloppiness. So I think that there's at least a chance that the judge may, in fact, dismiss the case against Hannah Gutierrez and free her. And to be honest, I think that would be the right outcome. I do. I think it's very unfortunate for the victims in the case, but we absolutely have to scrupulously guard defendants' due process, because when we do that, we protect our own due process rights. We protect our own right to a fair trial in case we're ever threatened and charged. So it is a much bigger issue. It is a much bigger argument than justice for a single victim. And I don't mean to sound harsh about that, because Helena Hutchins' life mattered, and it mattered to her family, and it mattered to her children. But the flip side of that is that we cannot allow the state that has nearly unlimited resources, unlimited power, to abuse their power in our system. Because if we do, we run the risk of our system being undermined to the point where it's meaningless. So it's a tricky balancing act. And I understand that there are many people who will be frustrated, as they were when Alec Baldwin's charges were dismissed. There are many people who will be frustrated if Hannah Gutierrez's charges are also dismissed. Do I believe that Hannah Gutierrez was culpable in the case? Absolutely. I believe that she was negligent in carrying out her duties as the armorer. She was inexperienced. She was not well supervised, and I think that that's all been proven. But the question is whether the prosecution stacked the deck against her. Had the prosecution simply pursued a fair process and done what the law required, then Hannah Gutierrez's conviction would very likely have still happened and very likely would have stuck. But that's not the case, because the prosecution committed the violations that really border on criminal. So they have violated the constitutional rights of Hannah Gutierrez and Alec Baldwin to the point where the only remedy is dismissal. So that is my 2 cents. It definitely gives Hannah Gutierrez a great deal more ammunition, pardon the pun, in her quest to have her charges thrown out, or at a minimum get a new trial. I don't think there's any question that she gets a new trial, but it's very possible that she could get dismissal. We also heard that Chad Doerman took a plea. Let me just remind you, Chad Doerman was a father of 3 little boys and came home one afternoon and executed them. There's no kind or gentle or soft way to say it. He was waiting on the porch for the police when they showed up. They took him into custody, His attorneys filed motions questioning his competency, filed that they were going to use the insanity defense. There also was kind of a major setback for the police and the prosecution in that case when the judge found that Chad Doerman had requested a lawyer, and the police continued to question him after he had invoked his right to counsel. However, there were so many eyewitnesses to the case that his confession was really only corroboration of what happened, not really truly the only, I mean, it was far from the only evidence that he committed the crime. So, but I think that his attorneys had asked, had made some inroads in bringing that motion, that motion to suppress, as well as some inroads on the issue of his mental health. At the sentencing hearing, at the plea and sentencing hearing, the judge did reveal that there have been 3 different mental health evaluations, and that at least, and that they did not all agree. So the prosecution decided, and probably absolutely reasonably so, this is a heinous crime, and this man deserves to be in prison for life. But it also was an incredibly traumatic experience for Doerman's wife, who tried to protect her kids, and for his stepdaughter, who ran away and who witnessed at least 2 of the shootings and ran away down the street, down and across the street to the fire department for help. She was quite young. I think she was 13, maybe. So both of them are absolutely and incredibly traumatized. And I think the prosecution took that into account in deciding to enter into a plea. So it wasn't a cut and dried case because the confession had been thrown out. It wasn't a cut and dried case because of the mental health issues. So I think the prosecution probably did the right thing. The prosecutor had to outline the facts of the case, and they're horrific. I won't go into them here, but the prosecutor went through those facts in order to put the factual basis for the plea on the record. And he was so moved, and this is an experienced prosecutor, male prosecutor. He was so moved by what he was saying that he had to stop several times because he was choking up. The judge heard statements from both Doerman's wife and stepdaughter. And following that, the judge imposed 3 life without parole sentences. He actually made them, he also imposed 2 felony counts for felonious assault, for assaults on Doerman's now ex-wife and stepdaughter, as well as the 3 murders. So he imposed life without prison. He also imposed somewhere around 16 years, made those consecutive. So there's no way that Doerman's ever going to be out of jail. And that probably was a just outcome. So, Tiff, this is a good question. And I'm not really sure. I don't believe he did. We have a lot more to talk about domestic violence when we get to the Ashley Benefield case. And I do want to talk a lot about that. It's a good question, and I can't for sure answer it. What I can say is that domestic violence did not come up in the sentencing hearing. And it typically would if there was evidence of prior domestic violence. Typically that would come up. So I suspect not, but I can't say for sure. It was not a factor in the facts that the district attorney laid out or that the judge discussed in discussing the sentence. So, but we have a lot to talk about Ashley Benefield. So we're going to get back to that. And of course, there's Sarah Boone news, because there's always Sarah Boone news. So at the last hearing, Sarah Boone informed the judge that she had filed 5 motions that she wanted the judge to hear. So yesterday, the judge heard those motions. The motions, for the most part, were pretty well argued and pretty well based. The first argument had to do with the first motion had to do with the judge allocating money for investigation. There is an investigator that's already been appointed. He remains on the case and has been very involved in facilitating getting all of the discovery on thumb drives and getting it to the jail, along with a safe laptop where she can use during normal business hours to prepare for her trial. You may recall that Sarah Boone went through 8 court-appointed attorneys. Actually, that's not right. She had 1 retained attorney. That person withdrew, and then she had 7 court-appointed attorneys. Not all of them withdrew because they couldn't get along with her. There were a couple of them that withdrew because they either had conflict because they had previously represented the victim, or in one case, the person accepted a job, I think, out of state and left. So, but at least 5 of those attorneys were attorneys who were replaced at her request because she couldn't get along with them. The last attorney that the judge appointed, Patricia Cashman, was probably their best hope. She was a very experienced criminal defense attorney, very savvy, and she definitely put in the work. She spent more than 20 hours with Sarah Boone going over discovery. She discussed trial strategy. But it was very clear at that point that Sarah Boone was never going to be happy with anybody. And Patricia Cashman just basically said she is going to have to represent herself because she is never going to be satisfied with anyone else. And the court agreed. And the court then entered a very lengthy and thoughtful, he refers to it frequently as his 16-page order, outlining his reasoning, the support of the case law and of Florida law in determining that she had run out of options for appointed counsel. The judge found that she had essentially waived her right to counsel because she couldn't get along with anybody that was appointed, and that she had forfeit her right to court-appointed counsel. And so she came back, she said, I don't want to be pro se, I want a lawyer. And she asked for the judge to appoint standby counsel. Now, I think she misunderstood. And I do want to point out that it's different from state to state, because there are states where courts do appoint what they call standby counsel. And those are lawyers who sit back and advise a client, a pro se litigant, kind of from the back bench. and I have seen cases where that's occurred. But in Florida, that is not what standby counsel means. In Florida, what standby counsel means is that there is someone standing by and prepared if at any point the pro se litigant says, I don't want to be pro se anymore and I want a court appointed lawyer. The judge pointed out to her that that is not available to her because she has now forfeited her right to court appointed counsel by her behavior. So the judge was very careful because right to counsel is a very serious constitutional issue. It's a very serious Sixth Amendment issue. And so the judge was very, very careful to outline very methodically and cautiously all of his reasoning in determining why Sarah Boone has forfeited her right to counsel and why it, in his opinion, it operates as a waiver. So I didn't get a hold of that, the actual order, but I would like to, because I would like to read his reasoning, and I will try and do that for next time. There was a kind of a small, nothing is ever small in these cases, but there was a procedural issue that came up in the Long Island serial killer Rex Heuermann case. Two things. The defense wants the cases severed. They want the first 4 cases and the next 2, the 2 that were charged later, to be separated. I think that the court hasn't had a hearing on it yet. They just filed the motion. So that'll be coming up, and we'll be watching for that to see whether or not the court is actually going to grant that motion. The other thing that is coming up is that there is some rumbling out there that that more charges are coming. I don't think that's a surprise to anyone. I think that the police, now that they have the body of evidence that they have against Heuermann, I think now they are just very systematically going back and comparing all of those open cases to the evidence that they have against Heuermann, and, you know, DNA and all of those things. So I think they're very systematically doing that. The other thing that is important to remember is that there was something like an incredible number of electronic devices. I want to say like 300. There were tablets, there were phones, there were prepaid phones, there were computers, there were hard drives. And so they're really only scratching the surface of all of the data on all those devices. You think there was a lot of digital data in Daybell. There's going to be exponentially more in Heuermann. First of all, it's just the sheer number of devices, and second, the period of time that these murders cover. I mean, these cases go back to 1993. So the sheer number and the time period, it would not surprise me if 5 years from now they are still bringing charges for victims, because that's how much data there is to sift through. So I think that we're really only at the very, very beginning of understanding Rex Heuermann and the Long Island serial killer case. Now I want to talk about, there have been some motions in the Delphi case. I do want to point out that Bob Mata from Defense Diaries he is in Illinois, and he has been attending the Delphi hearings in Indiana. The reason he's done that is because Judge Gull has refused to live stream or video any of the proceedings, and we expect that's going to continue through the trial. So really our only source of information are the filed documents and the notes of anybody who is able to sit in on the trial. Baba said he's committed to attending the trial when it comes up in October. So far we are getting lots of evidentiary motions in advance of the trial. They continue to try to get Judge Gull off the case, and it continues to be pointless. So, but they continue it and preserve the appellate record for later. So, Young Thug, holy cow. You talk about a case that has been a mess since the beginning and continues to be a mess. So the Young Thug trial is a RICO case that is going on in the state of Georgia. It is being prosecuted by the same DA's office, Fani Willis, who prosecuted former President Donald Trump, and who has had a lot of questions about the operation of her office, her own ethics, and I mean, the whole office is under fire. So today there was a hearing. Now, let me just drop back. Back in early June, the court began, I even have to drop back further to say, there are 6 defendants, co-defendants in this case. The main co-defendant is the one they call Young Thug. And the trial has to do with an African-American gang that either started as or was disguised as a rap record label. This is the case where Thug's attorney stood up, and Brian Steele, and said, I want to know what in the heck was going on, because the judge was meeting ex parte, means without the defense present, with the prosecution and a prosecution witness, and I want to know what went on in that meeting. Well, the whole thing blew up. The judge demanded to know how Brian Steele had gotten that information, and when he refused to answer, the judge held him in contempt and ordered him taken into custody. He then, there were motions filed on his behalf with the Supreme Court. The Supreme Court stayed the execution of that penalty being imposed. It's not really a sentence, the contempt penalty being imposed. And both Brian Steele and several other of the defense attorneys filed motions for mistrials, as well as motions to recuse this judge. This judge has been incredibly biased toward the prosecution from day one. No question about it. And the prosecution has been blatantly dishonest from the beginning, and the judge has refused to call them out. So after they continued to pursue the issue of this judge's recusal, he finally stopped trying to figure out who'd ratted him out, and agreed that the recusal motion, that he couldn't decide the recusal motion. Under their own court rules, it had to be referred to a different judge. And he had been wrong in repeatedly denying their motion to recuse him and making the decision himself. So the judge who heard the motion, while she sort of danced around the issue of whether or not the judge was culpable in the ex parte issue, she did find that he was inappropriate in the way that he treated the defense, and she ordered him recused. The first judge was appointed, promptly recused herself, and now we have the current judge, and I am here to tell you, I'm here for it. She is no nonsense, very straightforward, and she is putting up with nothing from anybody, and that includes the prosecution. And the prosecution is now on their back foot. So what happened was that, and now the prosecution has filed motions to also disqualify the prosecutors. And I think there's a chance the judge could do this. So we have to go back to when all this started. There was a witness who was coming on the stand, called by the prosecution, who was a part of this record label, and who had a lot of information about the workings of this gang that was somehow affiliated with this record label. So he was called to testify. Earlier in the week, his attorney contacted the prosecution and told them that his client, the witness, intended to invoke his Fifth Amendment right. He was not going to testify. Well, then the prosecution got an order from the court, an order granting him transactional immunity, which is basically immunity for the course of the trial, in return for his testimony. In Georgia, you cannot refuse to testify. You can be compelled to testify as long as you're given immunity. So the original judge, Judge Glanville, when the witness got on the stand, when the witness got on the stand, he answered a couple of questions sort of flippantly, and then said, I'm invoking the Fifth Amendment. And immediately, because you don't want the jury to hear that, the judge sent the jury out of the room, and he told the witness, Copeland, that if he didn't testify, he was going to send him to jail. He did, in fact, send him to jail, held him in jail over the weekend, and brought him back on Monday morning. Then on Monday morning, the judge, the prosecutor, the court security or his security, jail security detail, as well as a court reporter and a couple of prosecutors, investigators, all went into the judge's chambers, where they were for almost 2 hours while court was delayed, hammering on Mr. Copeland to get him to testify. After all that, he came back into court and testified. Well, his testimony was evasive. It was, he openly said, I'm going to lie. He said, I don't remember more than he answered any of the questions. And it very clearly was continuing to be a problem. So today, the judge called in. Today, this whole week has been a week of motion hearings and the judge taking up a bunch of things outside the purview of the jury. So the judge did say that she intends to call the jury back on Monday and begin taking Mr. Copeland's testimony. But she is going to instruct the jury not to consider any of the information since June 12th. So any of the information, the testimony of Mr. Copeland. Now, how do you unring that bell? How do you get this trial back on track? How do you tell the jury, don't consider anything he said for the last, from 2 weeks ago when he was testifying? So I think there's a real problem with this case. I mean, it has continued to be a real problem. I thought it was very interesting that at several junctures, she said things like the prosecutor's not doing herself any favors. And at one point, actually called out the prosecutor and said, you have misrepresented in your motion what this case says. I read the case, and it doesn't say what you say it does. And that is a misrepresentation to the court. And you have a legal and ethical obligation to for candor to the court. And I think it's been very clear that she is not impressed with this prosecutor, that this prosecutor is on her last nerve. So that being said, I wonder whether or not when she gets to the point of making some other determinations on some other motions, whether the defense may just get their motion, their dismissal. And it could potentially be with prejudice, as we saw in the Baldwin case. Here's why I say that. The judge is still considering some very serious discovery violations. Once again, we have a prosecutor who has not played fair, who has the whole purpose of Brady and of the Brady versus Maryland, which is the Supreme Court case that talks about discovery disclosure. The whole reason for the requirement that the prosecution provide all discovery to the defense is to level the playing field, because we know that the prosecution has nearly unlimited resources. The prosecution could say, I want I want this police investigation going on 24 hours a day. I want surveillance. I want police to dig into records. I mean, they can do just about anything. And the only real check on that is that whatever they do turn up, they have to turn over to the defense. So one of the things that came up both in this case and in the Gutierrez case as well, is both prosecutors argued, well, the defense found it anyway, so no harm, no foul. And, not to put too neat a bow on it, but that's just BS. That is just totally ignoring the law and the intent of the law. It's absolutely outrageous for this prosecutor to say it's not a violation if the defendant found it on their own. It's not a Brady violation. It's yet another, at a minimum, disingenuous. At worst, I would say outright lie perpetrated on this court. To stand there and argue that she doesn't have a Brady obligation because the defense found it is absurd. That it totally undermines the entire reason for discovery and for Brady. I do not for a second believe that this judge is going to buy that. She has already really telegraphed in the hearing today that this prosecution team is on very, very thin ice. And it would not surprise me at all for this judge to look at all of the conditions in this case and say, the discovery violations, here we are 18 months into trial. Remember, this trial has been going on that long. And there have been fits and starts, but this jury's been seated for a year. These jurors have been on this case for a year. And it would not surprise me at all for this judge to step back and say, it is indefensible that halfway through a trial where you've had a year to provide all this discovery, that you have not fully disclosed all this discovery, and you're now saying, oh, no harm, no foul, because they found it. Dismissed. I could see that there's a really good possibility that this judge could do that. She could say, I don't buy it. I'm not buying what you're selling. It doesn't pass the sniff test. And I'm going to dismiss the case with prejudice because I believe that the prosecutorial misconduct is so severe that that's the only remedy. Remember, this is a racketeering case. This is a RICO case. So what they did was, when they couldn't they couldn't pin down enough people to go after some of the other criminal behavior, then they decided to charge it as an organized crime organization and get prosecutions for those cases that way. And one of the reasons, thank you, Jen, one of the reasons why is because these people were all lined up. They weren't going to testify against one another. And the witness who has been the state's kind of main witness is Copeland. And he has been all over the board on what he says. One minute he says, I don't remember. The next minute he says, I lie. I always lie. I lie about everything. I'm lying now. I'm always going to lie. So it's really going to be difficult. And then we have the whole issue of the circus that his earlier testimony was. How does the judge unring that bell and say, oh, just disregard all that? He was just kidding. It's not going to work. So I will not be at all surprised if she declares a mistrial in this case. I feel terrible for the jurors who have been on the hook in this case for a year. It wouldn't surprise me if she declares a mistrial. And I think there's at least a possibility that she could declare a mistrial with prejudice, as we saw in the Alec Baldwin case, and could see in the Gutierrez case. Now, I want to finish up by talking, and I purposefully left this till last because I felt like I was going to probably get a lot of comments and questions about this case, and that is the Black Swan Ashley Benefield case. Now, I have to preface my comments with a little bit of explanation about where I come from. I have been involved in prosecuting, defending, and representing domestic violence victims, domestic violence cases for 30 years. I have taken classes. I've taught classes about domestic violence. I have been involved in groups and in nonprofit organizations supporting victims of domestic violence. So I want to be really clear and transparent about my bias, because I have some very serious concerns about the way this trial was conducted. Now, we all need to get the facts out there and understand what the facts were. Ashley Benefield was 23. She married a man who was 49 after knowing him for about 3 weeks. And that in itself has got to be a huge red flag. The man had recently, about 8 months before, lost his first wife to cancer. He had a teenage daughter and who was really only a few years younger than Ashley Benefield herself. They were married. They had a baby together, but from early on, at about the time that Ashley Benefield discovered that she was pregnant, his true colors began to show. He was exceedingly controlling. He was very abusive. He was a name caller. He was emotionally abusive. And she was very young and very, probably pretty immature and naive about things. They met at a Republican fundraiser. They were both gun owners and gun users, so there were guns in the house. When she became pregnant, she was very ill during the early stages of her pregnancy, and she went to live with her mother so that her mother could take care of her. And that was really the last time that they lived together while they were married. He, however, continued to try and convince her to stay married to him, to come back to him, to guilt her into remaining married. And she claimed that he was physically abusive to her for the first time, and that she was very afraid because it had been things had been building up between them, and that she shot him in response to him physically threatening her. Now, in Florida, they have stand your ground law. And in fact, they had a stand your ground hearing during which Ashley Benefield testified, and the court did not find that the shooting was justified. So we knew from that proceeding that the self-defense defense needed bolstering, and that's exactly what her defense attorney did. Her defense attorney claimed battered women's syndrome, and that although she had not been physically abused, she had been emotionally abused and mistreated for months. She had been controlled, called names, isolated, all of the things that happen when someone is being are subjected to what's called coercive control. Okay. So coercive control is just a part of what we know of as the wheel of power and control. So not all domestic violence, not all coercive control is coupled with actual physical violence, but all physical violence is coupled with coercive control. So if you all are interested, we can dive really much deeper into the issues of domestic violence, the law around domestic violence, all of those things in another episode. So if that is something that you that you want to talk about, please drop it in the chat or in the comments. I see a caution from Jen, who is our moderator. Please keep it classy. Yes, please do. These are really hard issues. If you have experienced domestic violence, you understand that these things are not black and white, that there is nothing simple or clear cut about the situation. Now, I don't know whether Ashley Benefield intended to kill her husband or not. I don't know. And I don't think anyone knows except Ashley Benefield. She claims that she was the victim of domestic violence. She claims that the story that she told was true, that she felt threatened, that she was afraid for herself, she was afraid for her child, and that she responded with deadly force. I think that we all need to take a deep breath and give, thank you, Lisa, and give her the benefit of the doubt. Now, is that reasonable doubt? I don't know. The jury didn't find that. The jury did not find reasonable doubt. The jury found that she was guilty of manslaughter. Manslaughter, states vary from state to state about the definition of manslaughter. Manslaughter usually is thought to be something that happens sort of spontaneously or in the heat of passion, or but not necessarily with any sort of intent or forethought. So that's usually the way that manslaughter is defined. Although I will say that it does vary from state to state. Every state statute having to do with manslaughter is a little bit different, and some group negligence into manslaughter. Some have a separate statute for negligent homicide. So, but as it was found in her case, she was found guilty of manslaughter because the intent piece wasn't there. I don't think that the malice and for a forethought were not there. The jury found that she didn't intend. She didn't go into the room and pick up the gun and intend to kill him. That in that moment where she was afraid, she shot him, and that's manslaughter. So the part that I didn't like was I didn't like the way the prosecutor characterized Ashley Benefield. I didn't like the way that the prosecutor diminished and belittled and almost made fun of her contention that she was a battered spouse. And I think that the prosecution made the error of saying no bruises, no domestic violence. And that is so far from what we know about in the prosecution, the defense, the definitions really of domestic violence. Now, I have over the years represented hundreds of petitioners, primarily women, although not exclusively, in restraining order hearings, in efforts to get restraining orders. Some states call them injunctions, domestic violence, family violence, restraining orders. I have both prosecuted and defended people who were involved in domestic violence assault, in instances of violating domestic violence family protection orders, and I have been, of course, involved in probably 100 child welfare cases where domestic violence was involved in some fashion. So I feel like I have adequate experience to be able to speak to what I found objectionable about the prosecution's closing and their arguments. Her argument really was kind of, you know, you can't prove that you were a battered spouse because you can't prove that there were ever any bruises. But we know that coercive control is a form of family violence. Controlling a person and never letting them spend money unless you approve it, the abuser approves it. Controlling what the person wears and what they wear when they go places. Labeling them a slut if they go out and they aren't dressed as the abuser thinks is appropriate. Isolating them from friends and family, keeping them away from people who are bad influence, who might be people who would call to that person's attention what was going on. I get the sense that Ashley Benefield was a very naive young woman. She was taken aback by this guy who was extremely charming and who really checked all her boxes. He was religious. He was a stand-up guy. He had been devoted to his prior wife. He had a child that he was devoted to. I mean, all on paper, he looked great. Later on, she discovered text messages between he and his first wife, where she was complaining about his controlling behavior, about his abuse to her, about physical abuse. She was complaining about controlling the way that he was controlling over their daughter. I mean, had these people actually had a courtship, I think there would have been a number of red flags, but they didn't really have a courtship. He met her, and 3 weeks later, they got married. I don't know what factors into that. I don't understand really the psychology, except that the only thing that I can come to is that Ashley Benefield was a very naive young woman who was swept off her feet by what she saw as this amazing love story, and a few months into it realized that she had made a horrible mistake. But she also had him on the other side saying, we made a covenant, they exchanged biblical verses all the time, so it's clear that he was pressing the issue of, you know, you made a promise before God and you can't walk away, and marriage is forever. And I think that was a great deal of pressure on her. They continued to attempt to have a baby. She became pregnant, and then there was a baby in the mix. So it's all very, very troubling. I found his daughter, who is now herself 23, I found her testimony kind of troubling, and I didn't really find her all that persuasive, but apparently the jury did. So she was found guilty of manslaughter, and I don't believe her. What happened, it was that a pre-sentence investigation was ordered, and I'm sure we'll get her sentencing before too long. So with that, guess I'm ready to take some comments and questions. I sort of left that till the end because I knew that we were going to have some, we might have a spirited discussion about it. So I don't, hi, Annie. Annie says, I don't understand the manslaughter verdict she received. Well, I'm a little mystified too, but the jury simply did not buy the battered woman defense. And I think that, I think that the defense did a fair job in bringing in an expert to explain it. The judge did limit those arguments in a pretrial evidentiary hearing. So the defense was a little bit hamstrung on what he could bring in and what he couldn't. I think he did a fair job. He brought in an expert who clearly was an expert and who could say, these are the signs that a woman is been subjected to coercive control that could include physical violence. But unfortunately, I think that the jury took the same position that was posited by the defense attorney, which I found very objectionable, in saying there was no physical contact, and so there was no domestic violence. And I kind of find that a little disheartening. So I hope that we are not going one step forward and two steps back when it comes to the recognition of the issues around domestic violence. So I kind of share your concern that it was hard to understand the jury's manslaughter verdict. I think they simply didn't buy her story and didn't believe that she was a battered spouse that would have justified a defense. Oh, my voice is going to give out here. Question: will you cover the Alexi Treviso baby death case in New Mexico? Yeah, I think I will. I don't know when it is scheduled. I have watched some of the coverage of it, and I think it's an interesting case. Great Laker. I think you're asking me what I think the Ashley Benefield sentence will be, and I'll get to that first, and then we can talk about Alexi Treviso. What do I think the sentence will be? I think the maximum sentence is 30 years. I don't think she's going to get the maximum sentence. I think the judge will take into consideration some of the mitigating factors, even though the jury didn't take them into consideration when finding her guilty. I'm not 100% prepared to speculate on what I think the sentence will be, because I am not that familiar with the sentencing matrices in Florida. So it's a Florida case, and the Florida judge will pass the sentence based under Florida law. And I'm just not that familiar with it, haven't done a lot of research on it. But before the sentence comes up, I'll do some research and we'll figure it out. Alexi Treviso. For those of you who are unfamiliar, Alexi Treviso was 19, so she was an adult. She was a cheerleader in her senior year of high school. And she complained to her mother that she was having very severe back pain, thought that she may have injured herself in a cheerleading practice. Her mother took her to the emergency room, and she was somewhat evasive, and they did give her medication for pain. They also did a pregnancy test. And before the results of the pregnancy test came back, she dashed out of the room and down the hall to the restroom, and in the restroom gave birth to a baby. She claims the baby was not alive when it was born, and she put it in the trash can in the restroom. She finally left the restroom after a prolonged period and threats that they were going to come in. And trailing blood down her leg and her bare feet, went back to the exam room. By that time, they'd gotten the pregnancy test results back. They sent a hospital cleaner in because the bathroom was covered in blood. And that cleaner found the infant in the trash. And they attempted resuscitation, but the baby was dead. When she was confronted, she said, nothing was crying, the baby was dead. The autopsy showed that the baby had at least breathed and was alive at birth. So that's going to be a somewhat interesting case. And I will be covering that trial if she goes to trial. I expect she will go to trial because I expect that the prosecution is not going to back down from prosecuting her for murder. And I expect that the only way that she's going to potentially escape it is if she testifies. So, good questions tonight. What other cases would you like me to cover? We've got some interesting trials that are coming up. Is her child with her mother? Oh, I think you're talking about Ashley Benefield. I believe that baby is, Ashley Benefield's child is with her mother. I know that the child's with family. I don't recall whether Ashley Benefield was, she was out on bond, I believe, prior to the verdict. And I think she was taken into custody at the time of the verdict. So I do believe that they've made provisions for the care of the baby, who I would think is about 2 years old now. Good questions. I don't recall wants to know, when are ex parte communications allowed in a case? Ooh, this is a good question. In general, ex parte communications are permitted when they are not about issues that could impact the ultimate outcome of the case. I would submit that an ex parte meeting between a witness who had already been sworn in and the prosecution should not have been an ex parte proceeding. Now, the judge in discussing the case said that she was not deciding whether the ex parte meeting was appropriate or not. She was only deciding whether or not the judge should have referred the recusal motion to a different judge. And the judge who heard the recusal motion recused that judge. Ex parte communications. So here's a good example of how ex parte is usually used. In a case where, and these are usually civil cases, where you are bringing, although we did see it in the Vallow-Daybell case as well, where you are bringing a motion before a judge, and that motion has the potential for giving away your trial strategy, or it is a procedural motion that doesn't have anything to do with the actual facts of the case. So in the Vallow-Daybell case, we saw the defense file an ex parte motion and asked for an ex parte hearing as it applied to Lori's competence. And the judge did hear that ex parte. The prosecution was informed of the motion after the judge heard the defense's concerns, and the prosecution was permitted to weigh in on the issue of Lori's competency. So in that case, what happened is the defense filed the motion. The judge said, I'm going to order a competency evaluation, which occurred. And then the prosecution was provided with the results of that evaluation. That was an attempt to protect the information that was given to the court to explain why the defense was concerned about Lori's competency. So that was a proper use of an ex parte communication. In general, you cannot use ex parte communication to get a leg up on the other side. And that arguably is what the prosecution was doing in the YSL case by saying to the judge, Judge, we want you to order our witness to testify or go to jail because we've given him immunity, and we want you to explain that to him in no uncertain terms. Now, the judge in today's hearing did exactly the same thing in open court and in front of the defense, which would have been the appropriate way for that to have happened. So ex parte is to be used very sparingly and only really in cases where you're either protecting a defendant's privacy and their right to a fair trial, or where it doesn't have an impact, a material impact on the outcome of the case. So they're to be used very sparingly. I question, while I question the number of times that Judge Boyce held hearings in chambers or discussed things in chambers, he did not do it ex parte. He did it with both sides present. So I didn't have concerns that they were inappropriately using ex parte contact with the judge. Good question. Something on my microphone here. Any other questions? I do want to say that if anyone wants to take a deep dive into domestic violence law, I'd be happy to do that. If you are interested in having me do that in a newsletter, I would consider doing that as well. Now that life has calmed down a little bit and I am not moving and I am not writing a book, I have more time to do some of those deep dives into newsletters if that would be helpful for anyone. So any other questions or comments? Got anything else for me, Jen? I see something here starred. Hi, Lori. Great seeing you since CRIMECON. Oh, there. Okay. Have you looked into the Micah Miller case in South Carolina? I've heard about the Micah Miller case, and it is a case that involves domestic violence, clearly. It is also a case of grooming. Now, I really feel like Ashley Benefield's case, although she only knew this man for a very short time, I think there was very clear grooming going on. And there was definitely grooming going on in the Micah Miller case. This was a guy who was a pastor. Micah Miller was part of a youth group, from what I understand. They had a relationship before she was of age. He then married her. And boy, you talk about coercive control and what had been going on there. My understanding is Micah Miller died, and my understanding is that the medical examiner ruled her death a suicide. There are a lot of people who believe that that her death may not have been a suicide. And there are a lot of people who have disagreed with the medical examiner's determination. And the fact that her husband has not been prosecuted or has not been accused of her murder. I think there are many more facts to come out about this case. I will say that if you have not followed Mandy Matney, whose channel is called True Sunlight, you'll find that in our show notes. She is the podcaster who was really instrumental in bringing to light the Alec Murdaugh case. She'd been on the Alec Murdaugh case since the boat crash, since long before the murders of Maggie and Paul, and she has been on that case ever since. She really focuses on crime in South Carolina, crime and corruption in South Carolina. And she and her partner, Liz Farrell, have been doing some very deep investigation into Micah Miller's case. She has got a ton of information about the case. She's probably the creator online who's really the expert. So I would highly recommend her. Her name is Mandy Matney, Matney, and her podcast is called True Sunlight. And she also does another podcast with Eric Bland, who is a lawyer in South Carolina and was involved in the civil side of the Alec Murdaugh cases. And that one is called Cup of Justice. So I would definitely recommend, if you are interested in those, looking in on those cases. So listening in on her podcasts. So, but do let me know if there are other Jane Blackbird, I'm always asking for the Larry Millette case that involves some sort of domestic violence. And that is one that I am continuing to look into and that we will talk about, because you have asked about it and I have looked into it, at least initially. And so we will talk about it. So thanks for reminding me. Anybody else? Question: are you going to discuss more details in the Vallow case? Feels like withdrawal. Oh, I absolutely am going to discuss more details in the Vallow case. Right now, we're in a bit of a lull. I think that we're going to see some movement in the motions for retrial, the appeal motions. And I think that we may see a loosening of some of the judges' iron fist around some of the evidence. And I am going to continue to pursue full and complete disclosure of all of that sealed stuff that the judge is holding very tightly. I am going to, and I will drop this on you now, next week, I am going to have an announcement that very well could be exclusive information as a follow-up to the Vallow trial. So if you want to hear a little more about the Vallow case and about the goings-on around the Vallow case, I suggest you tune in next week, because I may very well have a pretty important special announcement to report. And I don't mean to be too cryptic, but there are some things going on behind the scenes that I really need to help get lined up before we're going to be able to make an announcement. So stay tuned. And I absolutely will be covering Lori's trial when she goes to trial in February. I was poised to cover her Arizona trial that was scheduled for September, but the judge, over her objections, gave her defense more time. And so her trial is now set for February of next year. And I absolutely will be on that like white on rice, or stink on you know what. So, but thanks for the question. I don't want it to feel like withdrawal. I don't want you all to feel like I did my book and now I'm done, because that's very far from the truth. Lisa Lou, was there any corroboration of the abuse of Ashley Benefield? Just curious if there were any witnesses who testified on her behalf. You know, I must admit that I did not watch the entire trial, but it's my understanding that there were other witnesses who were able to corroborate the coercive control. She herself said that there was no physical abuse until the night, the day that the shooting happened. And then he started out by shoulder checking her, by, you know, sort of running into her with a box. He was angry, and that anger was escalating. And she went to her room, and then he blocked the door and wouldn't let her out, and then started coming toward her. So her testimony sort of paints a picture of this escalating behavior. I think there was clear evidence that there was coercive control going on. And coercive control can be a precursor to physical violence, but it doesn't have to be. It can be its own form of domestic violence on its own. So I think that there was certainly indication of that coercive control, but not corroboration of what happened the day that her injuries happened and the day that he was shot. Good question. Oh, Roffen Roffer? Okay. This is a really good question. Would I have advised Ashley Benefield to testify, or did it really hurt her to tell her story? Anytime you have a self-defense sort of defense, and in this case, it was a battered woman defense, you just about have to put your client on the stand. I think that really is the one real exception to attorneys advising their clients not to get on the stand. And I think that's the problem with that kind of a defense. In order to convincingly make the case that your client was acting in self-defense or was acting as a battered spouse, she has to tell her story. And really the only person who can tell the story of what happened in that room is her, because he's dead. So that is definitely the hazard of that kind of a defense, is you really don't have much choice. But that's a really good question. Yes, I absolutely will follow the Sarah Boone case. Her trial is scheduled now in October. It does not appear from the hearings that we've seen since she has been pro se that the judge is going to give her much latitude there. She is still complaining about the fact that it has taken a couple of weeks to get a process in place so that she can review her discovery. She initially wanted hard paper copies of all of her discovery, and the jail said, we absolutely cannot keep track of thousands of pieces of paper and assure that it's not misused or misplaced, or, I mean, we cannot be responsible to inventory thousands and thousands of sheets of paper. So the court has set up a process where all of that discovery was put onto, was stored electronically on thumb drives, and she is being given access to a laptop, presumably a dumb one that doesn't have online access, where she can review all of that. She was complaining about the fact that she can't take notes on pages, those sorts of things. But I do not dispute that she is at a marked disadvantage being a pro se litigant in custody. It is very limiting. There is no question. But it also is a case of she brought it on herself. And the judge was very clear with her when he appointed Patricia Cashman that she was going to be expected to find a way to work with that last lawyer, and she couldn't do it. I have no doubt that she is personality disordered and narcissistic, and none of those things excuse her behavior, and none of those things justify her behavior. So the judge said to her, you are responsible, and this is purely your doing. So as it stands right now, she is given access to her, thank you, Julie. Julie Reichart just said, Sarah Boone's a pain in the butt. I can't disagree. As a lawyer who's represented people like Sarah Boone, I can tell you it is a challenge. And there have been 1 or 2 cases where I have had to go back to a judge and say, Judge, I can't communicate with this person. I cannot get through to her. So, I have said this before. If I were Sarah's lawyer, what she would think of me is the same thing she thought of Patricia Cashman. She was mean, and she was terse, and she was short with her. And because here's the thing about the Sarah Boones of the world. The Sarah Boones of the world believe that if you don't agree with them, you have not heard them. Because if you had heard them, you certainly would agree with them. And that's the problem with Sarah Boone. And she gets frustrated with the judge because the judge will say, I understand what you've said, but I'm not changing my ruling. I'm not going to reconsider that. And Sarah Boone is one of these people who has been in the position for a long time of being able to beat people down to yes. She has been her entire life able to browbeat people until they finally agree with her just to get her to stop. And that doesn't work in the law. And so she has been unsuccessful in beating people over the head with, I'm innocent, I'm a battered spouse, you just don't understand. And she has been unsuccessful at beating people over the head with her opinions and making them say, okay, we get you. And that's not going to happen. So I think Sarah Boone would have found me every bit as frustrating as she found her last lawyer, who she asked the judge, tell her to be nicer. And to me, tell her to be nicer meant tell her to agree with me. But I have to give the last lawyer credit. She spent 20 hours with Sarah Boone. She gave Sarah Boone every opportunity to work with her. So I will be covering the Sarah Boone case. It's going to be worth the price of admission. So bring your popcorn, because I think she is going to get exceedingly frustrated with the limitations and the rails that she is going to be required to stay within in the rules of evidence and the way that courts conduct themselves. So I think she is going to get very, very frustrated because she is not a person who really likes to be told you have to stay within these boundaries, or, here's the rails. She's not good at that. So that is going to be entertaining and interesting. Now, at this last hearing was something that I didn't bring up. The prosecution once again asked the judge for permission to meet with Sarah Boone, because she is now representing herself, to discuss plea negotiations. Now, do I think they're going to go anywhere? Probably not. But the state is at least going to, and though the state has said they will record those conversations. Now, they will not be released. Settlement negotiations are private and they are not releasable. But I really think the prosecution is smart to cover their butts and be sure that if Sarah Boone starts misrepresenting what happened in that meeting, that they have a recording of it. I think that's very, very smart. I think if Sarah Boone was smart, she would negotiate and she would enter a plea. But I think she's smart, but I don't think that her mindset, I don't want to say mental illness, because she is competent. She is not mentally ill to the point of incompetence. But I don't think that her mental illness, just as with Lori Vallow, I don't think her mental illness would allow her to take a plea and make an admission. So I think she'd be smarter if she does, but because I think the prosecution at this point would be even willing to reduce the charges to something second-degree manslaughter-ish to be done with the case. I think that could be a real possibility. But over the years that this case has been going on, you all have seen the video of her, and if you can watch it, it's hard to watch. The link is in our show notes of her. She videoed herself talking to him while he is in the suitcase, and him saying, "I can't breathe, let me out, I can't breathe, please." And her taunting him and saying, "This is what you get," and clearly understanding that he was in there and he was telling her he couldn't breathe. So that kind of evidence, I mean, how do you get around that kind of evidence before a jury? I mean, I think Sarah Boone's going to say, "I was abused, it was domestic violence, coercive control, I was abused." But I don't know how well that's going to fly in the face of that particular video. So good questions. So we do have some kind of exciting cases that are coming up. I definitely will be following Corey Richens and her preliminary hearing that is finally coming up. It's rather odd to be saying a year down the road that we're just having a preliminary hearing, but that's where we're at. I will be double checking on James Craig, which I understand is supposed to start tomorrow. And y'all have asked me about that case. And we definitely will be following Delphi when it starts in October. And I will also be watching closely to see if there are decisions made in the change of venue for Coburger, because that could put that case in Boise. So we have lots of things to talk about and go forward on. Just wanted to double check my notes and make sure that we talked about everything that I had on my list. I'm going to be watching very carefully the Young Thug trial, because I think the legal issues in that one are pretty fascinating. Oh, Beth Riggenbach, thank you for reminding me. Adelson. I will be covering Adelson. Absolutely. We may do some special lives. I've even contemplated going down and sitting in on the trial for a couple of days. So we'll see whether I can swing that or not. But Adelson is fascinating. Oh, good question. The Lady in the Bahamas. That is, I had her name and now it just, anyway, The Lady in the Bahamas. As far as I know, she is still waiting for a trial date, but I will double check that one, because that one is interesting as well. She is a woman who solicited the murder for hire of her estranged husband. The plot was uncovered before they acted on it, and she and her lover and the guy that they had recruited to do the deed are all awaiting trial in the Bahamas. She is from Alabama, I want to say, or Georgia. but was in the Bahamas when this happened. And so she's being prosecuted under Bahamian law. The husband has their children, and she at one point was allowed to be released on an ankle bracelet over the Christmas holidays and allowed to go back to the US. But the last I heard, she is back in the Bahamas on an ankle bracelet and is awaiting trial. But I don't know when that trial is. So I am going to make a note on that one. I think that's about it for tonight. Did it hurt Ashley Benefield to testify? You know, I guess that depends on how credible the jury found her. It seems apparent to me that the jury did not find her credible because they found her guilty. So they definitely had some questions about her credibility. I wouldn't necessarily say it hurt her, but I think even if they thought it was going to hurt her, they didn't have a choice, because in order to get the battered spouse defense in, they had to put her on. So, but I think there's a possibility it hurt her, because obviously the jury didn't find everything she said credible. I think the prosecution was definitely able to poke holes in her story, raising reasonable doubt as to the defense. And then, you know, that's a finding for the prosecution. So good question. Oh, thanks for asking, Great Laker. My mom is doing great. The reason why I was not on last week is because she got moved. She moved. I shouldn't say she got moved. I talked a little bit about it right at the beginning when people were still joining, so you may not have heard. When we moved from Boise back to Central Oregon, in order to cause the least disruption for her, she stayed in her assisted living facility with her caregivers and all the people she knows, and her routine, while we came here and got settled into the new house. And while I shopped around and toured and made arrangements for her new assisted living place, I was super fortunate to find a very nice place just about the same distance from us and our new house as it was at the old house, about 5 minutes. And that makes it great because her little dog lives at my house and goes to visit her. And so it makes it wonderful that I can take him over and drop him off in the afternoon so he can spend the afternoon with her. And I do that 3 or 4 times a week. So, so last Monday, a week ago Monday, we hopped in our cars and drove the 6 hours back to Boise and picked up a small U-Haul truck. And I drove my car back with my mom, and my husband drove the U-Haul truck back. And then we unloaded it here into her new place. She spent a night with us at the new house and then was ready to move in the next day. I just saw her today when I went over and picked up the puppy, and she seems to be doing great. She's meeting new people and getting to know all the new people in her place. She's a real social butterfly, so she's having a good time getting to know folks. She still hasn't quite navigated a group to play cards yet, but I think that'll come. And now that I have a little bit of extra time, I'd like to go over once a week or so, and when she's got a card playing group, and play cards with them. And but she seems to be doing great. She's the new place is easy to find her way around, and she likes the food, and she seems to be pretty happy. The staff like her, and if anything, it was just that the staff at the place in Boise was really disappointed to see her go, because they really love her. One of her caregivers said, I'm really going to be sorry to see her go because she's so sweet, and I'm really sad because we just might get a grouchy person in her apartment now. So, but thank you for asking. She's going to be 91 the end of mid-September, and she's perking right along. So I'm happy to have her closer. I worry when I'm not close by. So I want to say thanks to everybody for joining us tonight. I missed y'all last week. I plan to be here same time, same station next week on Wednesday. So join us again next week for True Crime Wednesday. Good night, y'all. Have a great week, and we'll see you next week.